It consists of people from different strata of the society, different religions, and different educational and financial backgrounds. During the period of 2020 pandemic, digital transactions in the country increased manifold and digital assets have been on the rise in recent times. Meanwhile, the central government of the country implemented a new tax regime aimed at taxing gains and or income from virtual digital assets at a very high rate of 30%. The citizens of the nation were perplexed as to when there is no law legalizing the digital currency, digital assets, NFTs, etc., the decision to tax gains from the same is unreasonable. Thereafter, various citizens filed writ petitions before this Honorable Supreme Court, challenging the insertion of the new Section 115 BVH of the Income Tax Act. Thus, Honorable Supreme Court thereafter decided to hear the said petitions, and the issues raised in this case are mainly two, Your Lordships. First, whether or not the government is justified in taxing digital currency, digital assets, NFTs, etc., which is not legalized. And second, whether or not the Section 115 BVH of the Income Tax Act is violative of the Constitution of India. If Your Lordships are satisfied with the facts, the Council seeks your permission to present the issues on behalf of the petitioners.
Please proceed.
Much obliged, Your Lordships. Your Lordships, the petitioners would like to contend before this Honorable Supreme Court that firstly, taxation of virtual digital assets by the government is not justified. And secondly, Section 115 BVH of Income Tax Act is violative of the Constitution of India under Articles 14 and 19(1)(g) of the Constitution of Parliament. I will be dealing with the first issue, while my co-counsel will be dealing with the second issue. If I have the permission of Your Lordships, the Council would now move on to the first issue at hand.
Yes, please.
Yes, please.
Much obliged, Your Lordships. Your Lordships, while addressing the first issue, the Council would like to bring to the attention of the court that taxation would like to assert that the taxation of income accrued from VDAs at 30% is an unjustified move by the centre. There are several reasons that the Council would like the Lordships to take note of. Firstly, if we conduct a literal interpretation of the Income Tax Act, we won't find any head that provides for the taxation of cryptocurrencies or VDAs. It is agreed that Section 2, Clause 24 defines income. Section 14 lays out heads of income which tax shall be computed for. Section 28 clearly defines income which will be charged under the heads of profit and gains of business or profession. And Section 45 talks about capital gains taxation. However, Your Lordships, none of these sections clearly specify virtual digital assets, nor give a cause for us to interpret and infer the taxation of virtual digital assets under any of these given heads. In this scenario, it is extremely unclear, just basing our proof on the Act, whether cryptocurrencies will be taxed as profits or gains out of business, or assets, currency, etc. Further, Your Lordship, just to clarify one thing, in the case of Commissioner of Income Tax versus DC Srinivas Shetty, in consideration of the scope of Section 45 of the Income Tax Act, the judgment clearly stated that all transactions encompassed in any section of the ITA must fall under the governance of its computation provisions. A transaction to which these provisions cannot be applied must be regarded as never intended by that section to be subject of the charge. And that is how the taxation or the tax section must be read of the Income Tax Act. Your Lordship, with this, inference can be drawn that if VDAs are not defined, nor are they suitable to be placed directly under any of the sections of the Income Tax Act laid out, it is not justified for them to place a tax on such to determine that the Income Tax Act allows for such taxation. This, Your Lordship, the point is,
we'll have to leave the room and come back again, because even the respondents have left the room and we are not co-hosts, so we are not able to pin you, because only the team is visible and no other judges are visible.
And there is one team only present.
Yeah, even the respondents have left the group.
okay.
Okay.
Why have they left?
Don't know.
No
There's
idea.
some technical glitch. Can you call Manav and ask him, Tanvi?
Yes, ma'am.
Yes, ma'am.
Is the respondent's presence necessary to complete this session? I mean, the petitioner session?
We'll have to go back to the main session, sir, because we are not co-host right now. So we
No,
can
maybe do they, what Karthik is asking is whether they are required when the petitioners are doing their arguments, is it required that they also be present? Can they do their argument separately?
no, ma'am.
Ma'am,
Both
both
are
the team
supposed to
are-
be there.
Yes.
Okay,
the
okay.
team are-
Can you just call Manna?
Yes.
Yes, ma'am. Ma'am, we would require to leave this room and go to the main session. Then again, we'll be joining
All right.
in a few. Yes.
Dhanvi, are you here? Is this the main courtroom now?
No, ma'am. This is just a main session. We'll go into the rooms now.
Yes, ma'am.
Okay, Karthik has not come.
Okay, so it will go.
Yeah. Dhanvi, can you take us to the room, please?
One only.
Join, yes.
Who is the court master here?
Ma'am, we are there, but we are still not co-host now, ma'am.
Are you the co-host or are you not the co-host?
We are
Ma'am,
not the
actually, we are
co-host.
the co-host, ma'am, but we have not been given that right, so we are unable to pin you.
Okay, Rohit, who is Rohit? Does he have the right?
Yes.
Yes, ma'am, giving him.
Ma'am, actually, he has to give us the co-host rights.
Okay, Rohit, give them the co-host right, and then Dhanvi, I think you can take us to the courtroom.
Yes, ma'am.
Even you the cohorts, right? Okay.
Okay.
Yeah, ma'am. We have been given co-host rights.
Okay, now please take us to the courtrooms, please.
Room one. Yes.
Okay. Breakout rooms open kar.
Are they going to join now?
So Mridulika ma'am has to join now.
Okay. Okay.
Not joined.
All right, can we start?
Yes, ma'am. Sorry for the disturbance, ma'am.
Oh, that's
No
okay.
problem. How much time is left for the petitioners now?
I think for technical glitch, they will not mind.
Yeah, obviously removing
Yeah.
that.
How much time is left now from the time they had started?
Ma'am, it's 12 minutes.
All
All
right.
right. Petitioners, you all can start, please.
Yes.
Sure, Your Lordship. Just to quickly summarize from where we left off, Your Lordship.
No need to summarize. Just continue.
Sure, Your Lordship. Just to quickly summarize, I was on the point that the legal clarity wherein a cryptocurrency asset, whereas BDA is not clearly defined, and nor can it be charged as currency because a currency cannot be taxed. It makes governmental clarity as to the legality of such assets crucial in the matter as to what it does recognize as virtual digital assets or what it does not recognize as, whether it recognizes it or not. In such a scenario, what would be right on the part of the government would be to first determine the legal status of such currencies, followed by developing a systematic regulation system, and thereafter creating a clear taxation structure would help this cause. However, the government, Your Lordship, has neither accepted virtual assets as legal, nor has it brought about an action to provide for a regulation system which prevents the harms that it essentially claims to protect. The government claims that bringing out a taxation system might protect against the harms of these digital currencies. However, Your Lordships, it is agreed that cryptocurrencies pose certain harms, which the government has duty to protect its citizens. But taxing such income and not really instead of bringing in a regulatory system wherein you're trying to regulate the cryptocurrencies is not helping this cause anyway. It is only putting the citizens who are investing at a disadvantage. Neither are they protected against the investments, nor are they enjoying the income. In fact, they have to pay extra tax in cases where there are losses in such investments. This therefore proves taxation more harmful than fruitful for the economic health of the nation and its citizens. Your Lordship, in addition to this, the attitude of the government in the past has been to hastily place a ban on such virtual commodities. And now that it is not ready to determine the legality of such transfers, it makes the viability and the applicability of these assets very uncertain. And it also raises a doubt upon the government's intentions for the future. Does government really intend to bring about a regulation system? Because the government has not released any statement giving out that it is sorting out the problems, or is it trying to resolve the issues that are coming around with these virtual digital assets, nor is it trying to give the citizens the protection that they require and it is only bringing about a harm to those citizens who are just merely investing in those cryptocurrencies. It is bringing out harm, and it is also bringing in a lot of certainty as to whether the government will ever make these legal and put up a regulation system. There is even a chance of future ban. The attitude shows this, as in the past they've already banned this once, and the Supreme Court, Supreme Court in the rightist sense, has declared this ban as unconstitutional and said that the government cannot do this in the case of Internet Association versus RBI. However, it is contended that there is still the scope of a future ban and therefore it is absolutely unjustified that the taxation of the 30% tax is placed on the virtual digital assets. Not only this, your lordships, even even if they're trying to tax it under a particular head, VDAs have to be defined for this. And therefore, the government is not providing a definition. And therefore, the petitioners would like to contend that it is not justified for them to put up such a high tax rate, nor is it justified for them to put up a tax rate without bringing in any regulation in the first place. If your lordships are satisfied with this issue presented, my co-counsel will proceed with the second issue at hand.
Counsel, first of all, if you've summed up, I don't understand why you're saying that VDA is not defined. There is clearly a definition, yes?
Your lordship, the Indian government in section 115 BBH only intends to it does not define the virtual digital asset. The fact sheet nowhere mentions the definition of virtual digital assets, while it mentions the section 115 BBH.
No, 115 BBH, you are obviously referring it to the Income Tax Act 1961, correct?
Yes, your lordship.
In your memorial also, you admit to Income Tax Act 1961, yes?
Yes, your lordship.
Now, how can you ignore the definition of section 247A?
Your lordship, the fact sheet nowhere shows the introduction of section 247 into the Income Tax Act, and it only speaks about section 115 BBH.
No, that would be taking a very narrow view, madam. While I appreciate the precision that you're trying to bring, we will not have any fruitful discussion or argument without admitting to 247A. That is the whole issue, right?
Yes, your lordship.
Anyway, you have precision, you have my appreciation for that technicality. But considering 247A, what would you say?
Your lordship, even if we consider the introduction of...
Do you have the provision with you?
No, your lordship. But we have an idea of what to...
Can you say what it is, 247A?
Your lordship, the 247 widely describes what VDAs are and what the government considers VDAs to be, and for the purpose of taxation. And
so let's say we admit to the definition of VDA.
Yes, your lordship.
You are saying you don't have an argument?
No, your lordship, we do have an argument.
All right.
We're saying that the definition, even if the government is giving a definition, your lordship,
the government is not giving counsel. The parliament is giving.
Parliament is giving. Apologies, your lordship.
No, don't apologize. It's fine.
Yeah. The parliament is giving a definition. For sure, it is giving a definition in the 47.
Yes.
However, your lordship, to place a ban, this will be further taken up in the unconstitutionality of this section as well by my co-counsel. But to just summarize it in a shorter form, this section 115, the nature of income has not been defined.
I'll tell you. Do you have 115 BH with you now? BBH?
Once. Let's just. Yes, your lordship.
Please read it.
Your lordship, 1 second. I have a fair reading of it. Your lordship, even in the official website also, section 115 BBH is not present. I will just.
It's there. We have printed books with 115 BBH.
I will read the section. Give me just a second.
No problem. Take your time.
Yes, your lordship. I've
Please
got it.
read it.
Where the total income of an assessee includes any income from the transfer of any virtual digital asset, the income tax payable shall be the aggregate of the amount of income tax calculated on the income from transfer of such virtual digital asset at the rate of 30%, and the amount of income tax with which the assessee would have been chargeable had the total income of the assessee been reduced by the income referred to clause A.
Read subsection 2.
Subsection 2 states that notwithstanding anything contained in any other provisions of this act, no deduction in respect of any expenditure other than cost of acquisition or allowance or set off any loss shall be allowed to the assessee under any provision of this act in computing the income referred to in clause A of subsection 1, and no set off of the loss from transfer of virtual digital asset computed under clause A of subsection 1 shall be allowed against income computed under any provision of this act to the assessee, and such loss shall not be allowed to be carried forward to succeeding assessment years.
3 also, madam.
Okay. Your Lordship, we only got the 2 subsections here.
There are three subsections to 115 BBH.
The other one would be that no loss on account of virtual digital asset shall be carried forward to the succeeding assessment years.
No, that is 2B. I'm talking about subsection 3.
Go back.
Or shall I read it for you?
Yes, Your Lordship.
Please pay attention. For the purposes of this section, the word transfer, as defined in clause 47 of section 2, shall apply to any virtual digital asset, whether capital asset or not. All right, for your understanding, you must understand this expression, whether capital asset or not, first thing. Second thing, councils, come back to section 2A. It says, notwithstanding anything contained in any other provision of this act, no deduction in respect of any expenditure other than cost of acquisition, if any, or allowance or set off of any loss shall be allowed to the assessee under any provision of this act. Now, I'd like you, if not now, I'd like you to pay some attention to these provisions, because to my eyes, it looks like it is capable of being classified either as capital gains or an income from business, because otherwise there's no question of deducting expenditure, understanding cost of acquisition, and then the words computation of the income under any provision of this act. That itself shows that it obviously falls. There's some ambiguity because of the whole environment of cryptocurrency, but the provisions are not lost. There is some accuracy and traction in the provisions for sure.
Yes, Your Lordship.
If you have any answer or anything about this, I would like to hear.
Your Lordship, the petitioners would only like to say that there are parts of section 1. If we look at the Income Tax Act, every section, whether it be property or whether it be certain particular properties or any other assets, when they have been taxed, they have been given a clear procedure as to how they have been taxed. And it is very...
I understand what you said. The exercise that I have undertaken with you is to answer that only. That
Right.
These are not orphan provisions.
Correct.
These are to be read along with all the other sections of the Income Tax Act to understand whether it's business income or capital gains. For example, this section, councils, it appears in chapter 12 of the Income Tax Act. You must
Yes.
definitely read chapter 12 and understand what is the scope of that.
Yes, Your Lordship.
Chapter 12 contains many provisions and they're all to be read with all the 5 heads of taxation.
Yes, Your Lordship.
It's not an orphan provision.
Agreed, Your Lordship.
So
Your
there's no
Lordship,
definite answer. All right.
with your permission, can I just extend for 30 seconds and just make one point?
Yes,
there?
please.
Your Lordship, even if the nature of income, as your eminent Lordship has stated, that even if the nature of income is defined and it can be taxed, Your Lordship, 30% is something that has been, and the government has claimed that it is similar to gambling or betting, etc., and those activities. And various scholars have also, reiterated the same statement. However, Your Lordship, gambling and betting have been given a legal status. They have been discouraged, but the government is not doing that in this case. And it is saying that we have taxed it similarly. It wouldn't be justified on the part of government when you're saying that betting and gambling, you're discouraging against it, but then you're saying that we have taxed cryptocurrencies similar to that aspect. With that, I would give it to my co-counsel to explain the second issue further.
All right, thank you.
Good afternoon, Your Lordships. This is the co-counsel appearing on behalf of the petitioner. I would, with your permission, I would like to begin with the second issue, that is whether Section 115 BBH of IT Act is violative of Constitution or not. Your Lordships, it's humbly submitted that Section 115 BBH is clearly violative of Constitution, and that is why we believe that it is unjustified. Your Lordship, before I explain how, I would like to just state in simple words that the language, probably the language of the section is clear. Probably it has notified, it has brought it up, but still it is violating the fundamental rights under Article 14 and Article 19(1)(g). If we just read Section 115 BBH, it states that income from transfer of any VDA, that is virtual digital asset, will be taxed at the rate of 30%. This means that it is taxed on every transaction, irrespective of the level of income. Now, Your Lordship, we know that cryptocurrencies has been, people have started investing in it only after the COVID pandemic, and there can be people who merely invest, and those people who seriously trade in it. And if we are taxing every person at the same rate, this is clearly violative of Article 14. Article 14, right to equality, states that similar people have to be treated similarly and dissimilar people have to be treated dissimilarly. In the given case, people who get dissimilar profits are being taxed at a similar rate. And that is why this is violating Article 14. And with this flow itself, this would affect Article 19(1)(g), because what would happen is that, just a small example, Your Lordship, a person might be investing nearly 100 rupees, and that person might be getting a return of 70 rupees. And a person who's investing around 10,000 or 1 lakh would get 70,000. Now, the point that I'm going to make here is that people who are making mere investments, probably they would be hit by this section because they would face more losses, and comparatively people who get who would get larger profits, they would be satisfied even if it is 30,000, and 30 rupees on 100 and 30,000 on 1 lakh does have a difference, even though the rate is the same. What would happen is people who merely invest, they would be forced to leave this market, and this in a way is affecting their right to trade under Article 19(1)(g). Your Lordships, probably the government.
Could you recap why occasional investor is disadvantaged as compared to a big investor? I didn't follow that.
Your Lordships, probably
loss can happen to anyone, right?
Indeed, Your Lordship, but a person, but a person who is investing who's been investing into virtual digital assets from 36 months, that person must have had a stable an idea or a stable money that is flowing through such trade. And a person who's merely investing at the first, or who must have started a recent few months ago, that person would due to the volatility of this market, that person would immediately get losses, and this losses cannot be deducted from the tax rate or from the taxation also under Section 115 BBH. Moreover, Your Lordships, this loss cannot be carried forward to the next assessment years as well. So therefore, the small assessment player, the small investment players would be forced to leave this market, and they would not have a proper, reasonable right to invest as per Article 19(1)(g). Probably, your lordships, it might be the contention of the government to discourage them into investing in this, considering certain negatives of these virtual digital assets, investing into these. However, your lordship, I would like to bring your notice into two facts. When we talk about volatility, stocks, assets such as stocks and or people who invest in equity also have also involved into risky investment. But these are taxed considering the profits, the rate of the profit rate, the tax slab, the profit slabs that each person gets. If a person is a low earner, that person might be even taxed at the rate of 0% to 15% or to max 20% in my opinion. And even in gold as well, so which is considered as a fiat currency, that too does have a tax rate considering the level of income. Secondly, your lordships, if we consider this on an international level, there can be countries such as China who must have outrightly banned it, but we are not that country. We are a democratic nation who believe that people need to have the right to invest and trade, and it is not denied on part of petitioners that the parliament has the right to tax. The parliament has the right, irrespective whether it is legal or illegal. However, it should consider the people who are investing, the classes who get affected due to such law being done. Japan, a developed country, I would state an example of developing.
Council, can I stop you? Mridulika, you have anything to ask?
Yes, the point is you are treating cryptocurrency as if it is just 36 months old. But the fact is that it's been there in the market, or it's been there in existence for a decade long. So what makes you say that the government has not been doing its R&D for a decade, and then after that has come out with this regime? It has been there for 10 years. 10 years is quite a time to say that, okay, cryptocurrency, whoever is investing in it, the amount that is going in, they can afford, or they can afford paying up 30% as tax.
Indeed, your lordship. Your lordships, the idea of cryptocurrencies, if we go back to 6 years before, it would be a talk of elite people, and it would be a new fashion trend that people are investing in cryptos. What happened as pandemic has arrived, people started getting a source of passive income, and this is when people coming from lower or middle income after 2020 many people started investing it as a source of passive income for an investment purpose. And even
the forms are still not answered. See, even though even though you are saying it is passive income, what makes you say that it'll go back into the back burner after life gets better after COVID?
Your lordships,
even then, after that also, the elite only will be able to afford in investing into crypto, right?
Indeed, your lordship, the point the council here wants to make is that if a tax rate is made, let us consider that the tax rate is from 5% to 30% or even 10% to 30%. What would happen is, an investor would think that I'm getting 90% of it. Okay, let me invest in it. But 30% on a person whose passive income is less would definitely be not interested to. He would be discouraged to invest in these virtual digital assets.
So you are okay if the government is coming out with slabs?
Indeed, your lordship, indeed, because as we know that the government has the right to tax, and if the government has the right to tax, it needs to have a procedure established by law that is just, fair, and reasonable. If we talk about Japan, it has brought up a cryptocurrency legislation that taxes at the rate of 5% to 45%, mostly at the rate between 15 to 55% as well. But this is considering the income that is arising. Low earners would be taxed at the rate of 15%. Okay, considering certain developing countries, even Philippines has come up with a cryptocurrency before India as well, that taxes cryptocurrencies or virtual digital assets, considering the profits, the level of profits or the level of income of an investor. The
But
point that
council, what you have to see is you have to make sure, or else rather you have to look at cryptocurrency as a commodity. On that commodity, there is going to be a flat 30% tax slab that is going to be imposed. It's like any other product in the market.
But in your lordship, the council would like to humbly differ. If it is considered as a commodity or a good, it should be taxed under GST. While this is while this is considered as a direct
You
tax.
didn't make that argument. You
Your
didn't make
lordship,
that argument earlier.
your lordship, the council believed that that taxing under IT Act would mean that it is an asset. It is not considered as a currency, but is a means of exchange. And if it is considered as a commodity, it would be considered as under Goods and Sales Act.
You are okay, fine. You're saying that,
here I
right?
want to say, very good that you had have addressed this, council. Actually, can you tell me what is under the Income Tax Act? What is the levy? What is the charge?
The council would like to
What is the subject of levy in the Act?
levying.
What is the subject of levy?
The subject here is levying the profits arising out of virtual
Right.
digital assets
So
from
profit.
transfer of virtual digital assets.
So profit.
Yes, indeed.
Now, under the Act, the subject of levy is income. All right. The subject of levy is not the transfer, or the subject of levy is not the VDA itself.
Indeed, your lordship.
Now, in GST, the subject of levy is the supply of the VDA, if it would happen,
Indeed.
hypothetically. But here we are only concerned with the income or the profits that are remaining in your hands after you have sold or transferred the VDA. Now,
Indeed.
under Article 14, how are you similarly placed? Is it your case that you are dissimilarly treated as a VDA? I mean, is there any discrimination between two types of VDAs?
There is no discrimination as such, your lordship.
For example, there's a Bitcoin, or there's some Ethereum, and both of them have some different attributes. Is there any discrimination between these two, or they're hit with 30% straight?
Your lordship, the section does not give any differentiation, and it taxes every transfer of any virtual digital asset at the rate of 30%.
Then where is the discrimination, council?
The discrimination is at the place where profits a person is earning. The person who is earning, probably people who are investing might be earning just 100 rupees, and a person who's seriously trading, considering it can be a business income, might be crores. The profits that a person is earning being dissimilar in nature, considering the different economic strata that Republic of Parlamento has. This
So basically what you are saying is that 30% is, you're looking at it as a figure. You're not looking at it as a percentage. So the percentage that I will be paying, even though it is 30%, it would be comparatively a smaller figure, isn't it?
but
It is a proportion. It is a proportion that you're supposed to address about.
No. What you're saying is the progressive system of taxation that we already have in the slab rates. A
Yes.
richer person making more money will pay higher income tax. That is anyway there. You are saying you want the same parity in VDA also. Now I have only one question for you. How is this not legislative wisdom? Legislature is the will of the people. They can choose to levy tax however they want within the confines of law and constitution. They can pick and choose and say that this industry, I'm not happy, I will levy 40% on you. Are they within their prerogative as the head of state or not?
No, your lordship. The power, indeed, it is the power under Article 246 or Schedule 7 that gives the power to levy taxes. However, the tax has to be reasonable, and even if any law is passed, that is subject to judicial review.
That's true. I'm saying, when with regard to, suppose the rate of tax was 70%, say, that can be struck down as confiscatory because you're just simply snatching away assets belonging to citizens. 30% slab rate is not unheard of. Now, it is not your case that it's exorbitant. You're only saying it's difficult if I am taxed at a higher rate being an occasional investor as compared to a person who does it regularly. I'm saying both of you are placed in similar circumstances. That is what you need to see. Intelligible differentia is equals being treated equally. The word equals would mean you are doing the same trade in the same subject and in the same circumstances. Now, what your personal income is a different question.
Your Lordship.
And a person with lesser income, the legislature may be very well right in thinking, maybe a person with lesser income would not venture into these. Is there enough out there to think that this is something niche?
Your Lordship, even when we talk about a person being equal persons being put up in equal circumstances, there is certainly a difference if a person is being taxed under capital gains and a person who is taxed under business income. Well, but both of these are being considered as same under section 115 BBH. With your permission, I would just like to take 2 minutes, Your Lordship, to summarize.
Yes, good.
So the point that the council wants to make here is that firstly, the profits, the earning out of an investment can vary, and considering the tax brackets, it has not been made, and this would put up and this 30% would affect the persons who are getting low profits. And secondly, the nature of income. If a person is being taxed under capital gains and a person who is being taxed under business income, if they are being treated at the same place, then definitely this is against what IT Act itself says. IT Act itself has brought up 2 different sections under capital gains and business incomes. So if we are not bringing up a clarity, when we know that taxation as such is under strict interpretation, when it is giving a wide scope, the legislation, the parliament cannot give a wide scope to make laws or to take tax away. It is the duty, but however, it should be done taking a reasonable justification. Law is not an exception to the state. Your Lordships, the council would like to humbly conclude by stating that even though the government has the right to tax, it has to tax considering the fundamentals of the constitution. The profits or the nature of income are not being considered. The classification is definitely different as defined as what is capital gains and what is business income. And if we are bringing both of them in the same place, this is definitely putting dissimilar people at unequal circumstances. Therefore, this is violating Article 14. And in the long run, small players would be discouraged and they would be forced to leave the market, which is against their right to trade. Therefore, the council would like to state that this section 115 BBH is clearly violative of the constitution. The council now would like to proceed with the prayer. Thank you, Your Lordship. Clearly considering all the arguments presented by me and my co-counsel, and the seriousness of the duty of the government, which has not been done properly, even if it has the power to exercise, which has it needs to be done within the constitutional limits. As it has not been done, we would like to request you to it is pleaded before this honorable court to declare section 115 BBH as unconstitutional. And also it would be great if it is pleaded before this court to direct the government to bring up any systematic regulation system over these virtual digital assets, and moreover any other decision that can be in the interest of the general public health. Thank you, Your Lordship.
Thank you. Well done.
Thank you. Thank you.
Republic of Parlamento.
Respondents may proceed now.
Yes, thank you so much. Good evening to one and all present here. The council seeks permission to address the bench.
Please do.
Much obliged. Your Lordship, this is council number 1 appearing on behalf of the respondent in the matter XYZ versus the Republic of Parlamento. The council seeks permission to collectively address the benches, Your Lordships.
All right.
Much obliged. If your lordships are well versed with the facts of the case, the council seeks permission to summarize the issues for the same to this honorable bench.
Yes, respondents have the advantage to not state facts.
Much obliged, your lordship. So the council number 1 would deal with the issue of whether or not the government is justified in taxing digital currency, digital assets, non-fungible tokens, etc., which is not legalized yet. And its learned co-counsel, which is the speaker number 2, would be dealing with the issue of constitutionality. The council seeks permission to proceed on with the arguments of the case.
Yes, please.
Obliged, your lordship. So the council would like to deal with the first issue in two different limbs, wherein the council would first like to delve into whether or not it is immaterial to the government as to to proceed with the income obtained by the assessee is whether to ascertain whether it's legal or not legal, and then proceed to argue about the contemplations on the government's end so far regarding the regulation of virtual digital assets, which signifies the legislative aspect regarding their implementation and application. But before treading into the merits of the argument, at the outset, the counsel for the respondent would like to address the bench about the maintainability of this writ petition, which on the face of it is not maintainable. In order to buttress this argument, the council would like to rely upon the case of Madras Bar Association versus the Union of India, wherein the rationale of that case was such that the legislature must follow the principle of separation of power as enshrined in Article 14 by way of principles of equality between legislature, executive, and the judiciary. The Honorable Supreme Court also pronounced that the power to legislate on a particular topic or a subject is different from the power to levy tax. So, in the case of N.J. Joseph versus gift tax officer, thus it is contended that knocking the doors of the court regarding the justification on the end of the government when the amendments are regarding a want for a legislation should not be entertained. Doing so will teeth upon the parliament's powers, considering there is already a bill tabled at the parliament, the cryptocurrency and regulation of the official digital currency bill of 2021, which will soon supplement the general public with the necessitated answers. So regarding the first leg of the contention, it is respectfully submitted that the intendment of the legislature and the primary function of the Income Tax Act is to bring the income of various kinds into the tax mix. So the income tax authorities are not concerned per se about the manner or the means of acquiring income. Your Lordship, in the present matter at hand, the variegates of profits, loss, or income that arises out of a legal or non-legalized business, though not enforceable in law, does
Oh, counsel,
not render
just a moment. Sorry to interrupt.
Indeed,
Have you moved on from your objection on maintainability?
Indeed, Your Lordship, when the first leg of the contention.
Why are you saying it's not maintainable? I did not follow. On what ground are you saying it's not maintainable?
Your Lordship, there are two grounds. First one would pertain to the doctrine of separation of powers, wherein it says that the sphere of legislature and the sphere of judiciary must not coincide or must not be infringed upon one upon the other. So when this is about a want of legislation before the tax regime is put forth, it is a case that is entirely upon the legislature to deliberate upon. There is also a bill tabled in the parliament. And the second motion would be regarding Article 14.
No, stopping you here. This provision is inserted in the Act, yes?
Indeed, Your Lordship.
Enforcement date is notified?
Indeed, not Your Lordship. It's there in the Lok Sabha bulletin, but is yet to be considered and for legislative framework to be argued upon.
No, isn't it supposed to come into effect from 1/4/2023?
Your Lordship, as per the clarifications of the Moot committee, they have stated that although it is in pari materia with the laws of India, it is assumed to be taken into account, but this bill has not been finalized yet, so that can't be taken into account.
Suppose let's assume that it is notified.
Indeed, Your Lordship.
Then you don't have an issue on maintainability.
Your Lordship, even if that is taken into account, arguendo, any writ petition should be filed with respect to the third part of the Constitution, which is about the fundamental rights. So all the arguments made with respect to Article 14 and Article 19 by the petitioners do not have any legislative standing per se. Because even in the case of the co-counsel would actually...
That's all right. If they don't have a case on 14 and 19 1G, the writ would be dismissed. That's fine. But if they want to challenge the provision on 14 and 19, is the writ maintainable or not?
If they want to challenge,
I'm talking about maintainability. I'm not talking about allowing.
Your Lordship, I'm sorry, you broke.
I'm only asking if it's maintainable. I'm not saying if they definitely have a case. If they are pleading 14 and 19 1G and that the provision is unconstitutional and it should be struck off from the act, where else would they go?
Your Lordship, there is an alternative remedy in this particular case, which is essentially to wait for, that would be the second limb of the argument which the council would be contending upon.
No, I said assuming it is notified, then you don't have an objection on maintainability, right?
That is true. That would
assuming
be true,
it's notified. Yeah, I just wanted to get a clear answer from.
Yes, yes. Arguendo, it is notified, then the council would have no objection.
Right. All right.
So, Your Lordship, the council would like to brief the bench regarding the first leg of the contention, which is whether or not the government, whether it would matter, whether it is immaterial to the government or not about the legality of the income. So, Your Lordship, it is respectfully submitted that the intendment of the legislature and the primary function of the Income Tax Act is to bring various kinds of income into the tax net, right? So, the income tax authorities are not concerned about the manner or means of acquiring the income. Your Lordship, in the present case at hand, the variegates of profits, loss, or income that arises out of a legal or non-legalized business, though not enforceable in law, which is the case right now, does not render the profits out of the ambit of taxing, out of the ambit of the taxing statute. So the taint of non-legality of the business cannot be detracted from the same. And this was held in the case of Commissioner of Income Tax Gujarat versus S.V. Kothari. And on the similar instance, the Honorable Supreme Court relied upon the said case to pronounce that business income arising out of unlawful business will also be subject to tax and deductions for the expenses if it may be allowed. So this was held in the case of Commissioner of Income Tax versus PRA Singh. So therefore, buttressed by copious precedents such as the High Court of Calcutta in the case of CIT versus Lal Chatura Tea Company Limited, the position of law is well established that any transaction, whether legalized, regulated, sanctioned, licensed, authorized or not, it would still fall under the purview of tax assessment by the government, and there can be no bar as such regarding the justification.
Counsel, I have a question.
Indeed, Your Lordship.
Now, this proposition, there is no dispute. These ratios were laid before we were all born.
Indeed, Your Lordship.
No problem, no difficulty there. What the petitioners are saying is, there is a duty cast upon you to answer to the public and citizens of India as to what is this? Are you accepting or not? You only want to collect the money that comes from it and sit pretty.
Indeed, Your Lordship.
Now, is there a duty on you or not? Second, did you try to ban this earlier?
Indeed, Your Lordship.
Why did you try to ban it? What was the what is the parliament stand on banning it?
Your Lordship, to answer the first limb of your question, it would be that taxing. Okay, so considering the quantum of volatility of the nature of such transaction pertaining to virtual digital assets, there is so much volatility to a point where to get into the technicality, there is no source that can be plausibly identified regarding the transaction. So this would bear upon the government, this would burdenize the government in order to identify where is because since it's not backed up by any government tender, it's not even given the status of a legal tender, it is upon the government to identify the source of the tax, the source of the income in order to legislate or regulate for the same. So taxing it would be the first step in regulating it without a need for a legislation, is what the respondent is trying to contend.
Madam, here taxing and regulation would be two different functions of a state. If you see traditionally, these are the two opposites of a state. They are called taxing powers and police powers. Regulation is police power. What you're saying, regulation is police power. Taxing is the other power. These are two coins of the state. This is the legs on which all of us are standing today.
Indeed, Your Lordship, but
now, okay, I take your point that you want to regulate it, it's booming, etc., etc. Now, when you have already tried to ban it and now you are pushed back, you are trying to bring a law seeking to levy income tax on it, fine. But what is your stand on it?
Your Lordship, that would be the second limb of your question. In the
All
case
right.
of Internet Mobile Association of India versus the RBI, wherein the impugned circular of RBI circular of 2018, it was the aim to ban all the private cryptocurrencies and any transactions regarding it. This is only with respect to all the private cryptocurrencies because this would also add up to the volatility because that is on the end of the government they're still coming up with a since this is all in a developmental stage. There was a high level interministerial committee called the GAR committee formed. All the G20 starting from G7 to G20 of the world nations communique was all taken into account in this particular case. All of them were taken into consideration, and there are still deliberations going on regarding banning it or not banning it. Whilst the RBI is still coming up with a simulation of digital currencies, which is currently it has been rolled out just recently. There is a digital rupee being released. So on the end of the government was on a position to ban it, it needs to regulate it first and understand the idea about the volatility in order to bring about a legislation. Otherwise, the legislation will be entirely vague, and again, that would be the subject to amendments, cases upon case. It would ruin, it would take a toll on the judicious time of the court, etc., etc. So, in order to avoid all such ramifications, the government thought it would be ideal to tax it first and then bring about a legislation after studying it. So the GAR committee report, which was tabled in the year 2017, came up with, it acknowledged the idea of digital currency ushering into a new era of innovation and digital age of Parliamento. At the same time, it also thought about all the regulatory and legal risks such as immutability, due diligence, know your customer transaction, anti-money laundering and tax evasions, and even anti-terrorism at that instance. It is only upon the government to actually take all of these into consideration, and that is why a bill is tabled which aims at banning only private cryptocurrencies. Of course, it is only safe to think that there might be a near future where even the private cryptocurrencies are taken into account. But as of now, owing to all the substantial volume of transactions that are taken into play, only this is possible. So taxing it would be the first step to regulating it.
Your general knowledge on the issue is well appreciated, but don't connect tax and regulation. Both are polar opposites.
Understood, Your Lordship. So the
All right,
second limb
proceed.
of the argument by the council would actually satisfy your answer even more. So, Your Lordship, income generated by those means are generally called res extra commercium, and the government felt the need to provide for a new scheme of tax regime owing to the substantial jump in the volume of virtual digital assets that are being traded and invested in. And not only that, the power of exigency to levy tax on behalf of the government, granted under Article 265 of the Constitution, is the first step to regulating the volatile nature of financial technology in such magnitude, because nearly 43 trillion transactions are happening on a daily basis in this platform. And the idea of allowing such income to escape the tax net would be nothing but a premium or reward to a person who is doing such non-legalized trade. So who are all succumb to the lucrative interests which are offered by this niche platform. So at this juncture, there arises another equivocal question as to whether or not virtual digital assets are hit by Section 68 of the Income Tax Act, which talks about unexplained cash credits and investment, which is attracted regarding the functional nature of the virtual digital assets. As a whole, to which the Council for the Respondent pleads in negative, because the income is coming from an explained source because taxation is there for the same. So awareness regarding non-clarification on the government's end is to be thwarted, as taxing an income of such a volatile nature is the first step to regulating it once again and bringing it under the control of the government. Arguendo, Your Lordship, even if a hypothetical question has arisen regarding the dilemma as to a transfer of virtual digital assets are a business income or a capital asset, the taxing statute under the impugned section is harmonious on both ends. So since income from virtual digital asset is not an unexplained source, they are both business income and capital income. Your
Where do
Lordship,
you get
moving
that?
on to the
Where do you get that they are capable of being capital gains or business income? Where do you get that?
Your Lordship, if the the section 115 BBH is kept for perusal, it is actually wider in nature. So it talks about just am I audible? My
Yes, we can hear you.
sorry, Your Lordship, sorry for the inconvenience. So it talks about, since it's wider in nature, it talks about both. If it with respect to the transfer, cost of acquisition, and gifting taken for consideration, or mining of the cryptocurrencies are all taken into account. It talks about for what purpose is a consumer, for what purpose is the assessee for the same is keeping the transaction, assuming that Your Lordship, the concept extension.
We'll allow you 2 more minutes because I have one more question.
Much obliged, Your Lordship. So, with respect to what purpose is the assessee keeping the transaction of in the VDA for? Assuming, hypothetically assuming I have one Bitcoin in my account, for what purpose am I keeping it would be subject to under what slab it is falling. If I'm keeping it for investment purposes, then it will go under capital gain. If I'm keeping it for business purposes, then it goes into business gain. Because either way, section 115 BBH is not concerned about it since it's wider in nature.
All right, that's a good explanation. Now, if you see 115 BBH 2A, you want to say that you will not give any deduction in respect of any expenditure, allowance, or set off of any loss, except for what are you allowing for the poor assessee?
Set of transaction.
You are allowing the cost of acquisition.
Indeed, Your Lordship.
Now, when you are allowing the cost of acquisition, why are you not allowing other expenditure? Where is the differential between these two? In fact, that's a question which the petitioners ought to have raised.
Your Lordship, there is also 1% TDS which is to be taken into account, because when it comes to transfer, the petitioners have raised a concern regarding GST. GST talks about service of the same, because mining in this particular case would come under service, and the government.
No, I'm not asking that. I'm not asking that. Suppose there is a person dealing in VDA, and you are saying that it might be a capital asset liable to capital gains. There are 10 other assessees paying capital gains tax. Okay. Understand this. Hypothetically, there are 10 other people paying capital gains tax. They are paying 10 and 20%. You want the VDA people to pay 30%. Fine. You have some play there. You have a prerogative. But for all those other people, there is indexed cost of acquisition. There are allowances and deductions. But for VDA, which you admit is a capital asset that can be subject to capital gains as per the provisions of the Act, why are you allowing only cost of acquisition and not anything else?
Your Lordship, allowance are set off for cost of acquisition alone is not there. But when it comes to transfer of virtual digital assets, then this can be applied.
All right, let me put it in another way. You take cognizance that this is a business which can be done.
Indeed, Your Lordship.
Today, it is not an illegal business.
As of now, not yet. It's not illegal.
Today, it is not an illegal business.
Indeed.
So there are 10 people doing legal businesses. 9 of them are getting the benefit of expenditure. Why is VDA not getting if it's a legal business?
It is not. That is what the council is trying to explain, Your Lordship. It is yet to, in order to understand the source of the transaction, because 1% TDS, tax deducted at source.
No, my question is purely legal. It's not on facts at all. Just on the premise that it's as legal as any other business. If it is as legal as any other business and everybody is getting the benefit of claiming expenditure and losses, why are you singling out, or rather being harsh on VDA when you yourself know that all your citizens are using it, buying it, trading it?
Your Lordship, that 30% is not a figure as a whole. It should not be taken into consideration as a figure as a whole. Assuming the one Bitcoin, taking into consideration the previous hypothesis that I put forth, I have one Bitcoin which amounts to 100 rupees. So 30% on 100 rupees would be 30 rupees. But whereas the other business, there could be another person, say my co-counsel is also dealing in Bitcoins, she has more than one. So the 30% is not a standard one, is all the council is saying. Henceforth, even taking your question into consideration, the 20%, the discrimination or intelligible only equal when it comes to the doctrine of equal classification, reasonable classification, only equals can be taxed or equals can be charged considered equally. So this is an entirely different set of transaction that one would be dealing with, knowing its volatility and its risks. The
All right.
government on its end is trying to first curb the lack of illiteracy, lack of literacy on this end. So once when a person is indulging in such transactions, they must know the repercussions and ramifications of the same. So they cannot contend that once all the income they have gained thus far is different from, they've gained from a different set of business income, telling that they have paid only 20% tax there but 30% here, because
All
they're
right.
entirely
Point taken.
different set of
Point taken. Point. You can conclude. I think your time is up.
Much obliged, Your Lordship. So, Your Lordship, it is humbly submitted that the various actions and contemplations on regulating and legalizing virtual digital assets on the government's end are meted out chronologically. They serve as a green signal in bringing about a plausible legislation in the near future to supplement all these growing lucrative interests in the niche of virtual digital assets of the people of Parliament. So, at this conflict, it is respectfully argued that it is not necessary to bring about a legislation in order to tax a particular income. The compendium, if Your Lordships have the compendium of the respondent, there are several GAR committee report, the RBI circular, the case laws, all of them are provided. So the council would like to direct the honorable bench's attention there, which would talk about why the contemplations on the end of the government significantly provides for a near future legislation. So even in the case of Hitesh Bhatia versus Mr. Kumar Vivekanand, the court held that while cryptocurrency is not a legal tender, all the transactions have been compliant with the general should be compliant with the general laws, and it is also synonymous to the current legal positions around the world, especially in Japan and Canada. So, Your Lordship, the council would like to conclude their argument and over on to the co-council by stating that the government is legalized on their end to tax the cryptocurrencies and virtual digital assets first, and then move on with the legislation. It was an honor arguing in front of his honorable bench. The council would now like to request.
Thank you. Pleasure.
Speaker number 2, you have 14 minutes left.
I'm sorry. I think I asked a question too many.
Am I both audible and visible, Your Lordship?
Yes, you are.
May it please the Honorable Court, this is Counsel 2 on behalf of the respondent and the present case XYZ versus Republic of Parliament. Counsel 2 appears on behalf of the respondent. Counsel seeks permission to address this bench collectively as Your Lordship.
Please, please.
Counsel 2 will be dealing with the second issue, that is whether or not Section 115 of 115 BBH of Income Tax Act is violative of the Constitution or not. It is humbly submitted before the Honorable Supreme Court that the Section 115 BBH of the Income Tax Act is not violating the Constitution. Constitutional violation can be raised when any act is violating Part 3 of the Constitution or any other article, or if the legislative act is made on the parts other than that is vested in the Schedule 7, Your Lordship. As there is no violation or abuse of power other than vested one utilized to levy the tax upon the BDA, it is contended that it is constitutionally valid, Your Lordship. Section 115 BBH of the Income Tax Act deals with the taxation upon the income earned through the transfer of BDA, Your Lordship. When coming to the tax levied upon the BDA, irrespective of the legal position in the country, that is whether it being legal or illegal, it can be taxed because under Income Tax Act, the tax can be imposed upon both the legal and the illegal income. So therefore, cryptocurrencies or NFTs should be deemed, if it has been deemed as capital assets, then it can be purchased by the taxpayers. At the same time, whatever the income that have been achieved through the transfer can be taxed. If the VDAs are not considered as capital gains but are considered as the income under business or profession, then also it can be taxed, Your Lordship. On the other side, if it has been held to be illegal income also can be taxed under this act. So that is why the power was vested with the Parliament, Your Lordship. Section 115 BBH is not violating its fundamental rights of the Constitution like Article 19(1) Clause D and 14, Your Lordship. So it is intravirus to the Constitution. And in the case of Mohammed Yassin versus Town Area Committee, it was held that the right under Article 19, Clause 1, Clause G is effective when in effect and in substance, the informed measures brought about a total stoppage of business, both in a commercial sense and from a practical point of view, even though there was no prohibition in the form. So, through imposing tax upon the income upon the whatever the executive transfer doesn't stop the business or the trade, your lordship. So, it is not violating Article 19, Clause 1, Clause 3, your lordship. Writ petition doesn't pertain to the existence because in what way the fundamental rights are being violated or not being or clearly stated, your lordship. And it was held that it is not exhaustive of entities in the list leads to the interference of the taxation is not intended to be compromised in the main subject in which it might on extended construction be regarded as included, but is treated as a distinct matter for the purpose of legislative competence, your lordship. And in the case of Govind Saran, Ganga Saran versus CST, the components which enter into the concept of tax are well known. The first is the character of the imposition knows by its nature, which prescribes the taxable event attaching the levy imposition of tax on income obtained by the VDA. And the second is clear indication of the person on whom the levy is imposed and who is obliged to pay the tax. And here, the person who is getting the income from VDA is obliged to pay. And thirdly, the rate at which the tax is imposed. According to the section 115 BBH of the Income Tax Act, the tax rate is 30%, your lordship. And fourth point is that the measure or value to which the rate will be applied for computing the tax liability. Here, under section 115 BBH, the clause talks about how it can be levied by decreasing the cost of acquisition and other components, your lordship. As these components are clearly and definitely ascertained, it is to say that the levy exists in the point of law. The legislative scheme defining any of those components of the levy will be through its validity, your lordship. So, in this connection, Supreme Court held in the case of synthesis and chemicals with the state of UP. In this decision, the Supreme Court observed that the Constitution must not be construed in a narrow or pedantic sense, and that the interpretation which is most beneficial given the widest possible amplitude of its power must be adopted, your lordship. India has not been immune to the phenomena of cryptocurrency, and the recent Supreme Court judgment opens doors for the development of the crypto market in the India. And the effect of the judgment is that it allows banks to provide banking services to participants in the crypto market, which was earlier banned by the RBA, where the circular has become unenforceable in the light of the case of Internet Mobile Association versus RBA. So, against this backdrop, the crypto exchanges are willing to enter into the derivative segment, your lordship. So, the judgment has also opened up the gates for the market makers to enter into the market for derivative trade. They are essential for a vibrant derivative segment and ensure that the risk can be transferred to the one who is better suited to take. As the Supreme Court set aside the ban on crypto transactions in the earlier case which have been stated, it shows that the virtual digital assets are not prohibited by the law in the country. Regarding the legal status of the income of VDA, in either case of income through VDA being held legal or illegal, they can still be tax can be levied, your lordship. And when coming to the question of the proportionality, the learned counsel for the petitioner relies upon the four-pronged test which has been held in the case of Modern Dental College and Research Center versus State of Madhya Pradesh. In this case, when coming to the four tests, firstly, the measure is designated for a proper purpose, and secondly, the measures are rationally connected to the fulfillment of the purpose. Thirdly, there are no alternative less invasive measures. Fourthly, there is a proper relation between the importance of achieving the aim and importance of
Counsel, I appreciate the principles you are elaborating, but please meet the contentions raised by the petitioner as today. They are aggrieved by 30% slab, they are aggrieved by deprivation of expenditure allowances, and that is why they are saying it's unconstitutional.
Indeed, your lordship. When coming
And
to
the lack of legislative.
No, on the question of the legality, I think we have discussed enough, but I think you can discuss and throw some more light on the slab rate and the subsection 2A.
Indeed, your lordship. When coming to the slab rate, which is 30%, here 30% tax, whatever imposed upon the VDA is the proportion rate, your lordship. So it depends upon, it is equation with the income, whatever they are arising through the trade of the VDA. For example, as my co-counsel stated that if the Bitcoin has the worth of 100, the tax rate is 30. in the similar way, if the Bitcoin income, if you are achieving through the transfer is 200, it would be 60. So it changes with the income. So it is legally valid to impose the 30%, as it is a proportion rate to the income whatever they're achieving through the transfer, your lordship. That is when coming to the slab. And next, when coming to the legislative competency, the
So
other council is
what you've just justified or explained is how percentage works. That is fine. Percentage ad valorem rate is fine. But why have you chosen 30%? Now, there are some other provisions also under Chapter 12 which seek to levy flat rates. What I have seen today are 10, there are slab rates of 10, 15, 20. Now, it's a double prong effect. You're taking away the claim for expenditure, but at the same time levying 30%. Isn't this harsh? For what reasons are you being harsh? You have rights, you have your own will, you have wisdom, but when the question is raised, you should answer it.
Indeed, your lordship. When coming to the rate by 30%, it is the government who decides the rate upon the tax for that particular each
Not the
separate.
government council, parliament.
The
You are the
parliament.
parliament.
The parliament. It's the my apology, your lordship.
No
It's the
problem.
parliament who decides the tax upon what rate is applicable for what kind of income or the head which comes
Yes.
to your lordship. So that is the reason they have levied 30% on that. And when coming to the determination of tax, they have decreased the cost of acquisition value, but not the other losses whatever they have suffered, your lordship, because they are still trying to regulate it and determine it in a proper way where they're going step by step to achieve that, your lordship.
So because you're in no man's land right now, you want to be very tough on the crypto market. That's the indirect answer.
No, your lord, I mean that's not
Then
what
do you want to say that you are consciously the republic? Are you consciously being tough by levying 30% and taking away expenditure because you don't know what this market is, or you're saying that it is a justified levy and it's not harsh?
council would contend that it was the justified one and it is not harsh upon the income whatever.
Why? Because the other businesses are enjoying, let's say even 30% slab. Let's say the rate is fine. Why take away the benefit of expenditure and only give cost of acquisition? And one more thing, which I forgot to add there, when you're allowing cost of acquisition, that becomes relevant for capital gains. But when you're doing it as a business, are you going to allow the cost of acquisition? Is that what the intendment of the section is?
Your lordship, in the section 115 BBH, they have mentioned that under the clause, if the transfer can come under the capital asset or other areas. So when coming to, so it is same for the both when it comes under the heading of the capital asset as well as the business or profession, your lordship. According
both categories, you are going to allow cost of acquisition.
Yeah, indeed, your lordship.
All right.
According to the section, whatever it has been.
That is why we are asking you. You have written the section.
Indeed, your lordship. So we are allowed. In
Any other
the
question,
light
Lulu?
of the section.
No, I have no questions to them.
Council, can you say why you are silent on GST? Now you have identified this as an asset.
It can be either as an capital asset or the income which has been attained from business or profession. Or
Not that. I'm not on capital gains and business income now. You have defined virtual digital asset.
Yes, indeed, your
under
lordship.
section 247. You admit that it is capable of being a capital asset.
Indeed, your lordship.
Yeah. Now, if you read the definition, do you have the act with you, the Income Tax Act?
Indeed, your lordship.
Can you go to section 214?
Your lordship.
Can you go to section 2 subsection 14?
Can you give me a minute, your lordship?
Yes.
Indeed, your lordship. 2 clause 14.
Please read the opening words and subsection A.
Indeed, Your Lordship. 2 clause 14 talks about capital asset means property of any kind held by an SSC, whether or not connected with his business or profession, but does not include clause 1 any stock in trade, consumable.
That's fine. That's fine. So it includes any property of any kind held by an assessee.
Indeed, Your Lordship.
Yes. Council, you are the Republic of Parliament, or you are supposed to know your laws. Have you glanced through the GST Act?
Council is aware
All
in a
right.
light way. Your Lordship.
Now, would you say that when I sell crypto Bitcoin today, is there GST on that or not? I'm one clarification to the court masters and even the council. This is a very important burning issue. That's why, although it's not part of this, I'm asking this. So feel free to answer. No pressure.
Council is not aware regarding this.
No problem. No problem. Basically, the premise is that when it is movable property and you are selling it in the market today, there is a clear scope of levy of GST also, and the Republic is being quiet about that. Just give us one more moment. Yes, I think that's all I have.
If Your Lordships are satisfied, Council would like to move on with the prayer, Your Lordship.
Yes, please.
Prayer. Wherefore, in the lights of the facts stated, arguments advanced, and authority cited, it is most humbly prayed and implored before the Honorable Supreme Court of Parliament so that it may be graciously pleased to adjudge and declare that the government is justified in taxing BDS which are yet to be legalized by the same. And secondly, Section 115 BBH of Income Tax Act is not violative of the Constitution. And also pass any order that the Honorable Court may deem fit in the favor of the respondent to meet the ends of equity, justice, and good conscience. For this, the act of kindness, the respondent shall be duly bound in forever. Pray, Your Lordship.
All right. Rebuttal.
I can take 1 minute of rebuttal, right?
Yes. Court masters.
Can I take 1
30
minute?
seconds are allotted for rebuttals.
Thank you.
30 seconds are allotted for the rebuttals and sub-rebuttals.
Okay, thank you. Not an issue.
You can take a minute. It's all right. We'll allow it.
Thank you, Your Lordship. Your Lordships, if my opposite learned counsel was constantly stating that due to the risk of volatility that is there in investing of virtual digital assets, we are imposing this steep rate of tax of 30%. Well, this volatility exists in equity such as stocks and also in gold as such as fiat currency also. Why this stringent tax policy, irrespective of nature of income or level of income, is only limited to virtual digital assets? And when this is given, isn't it not violative considering the level of profits that is different? As the level of profits are being different, don't you think that dissimilar people are being treated equally? And this is clearly violative of Article 40.
Is that a question to the bench or the other council?
The opposite council.
All right.
Moreover, Your Lordship, my opposite learned council stated that to bring up a proper regulation system, before that we are bringing up this taxation policy. However, Your Lordship, there is no indication of when this legislation or regulation will be passed. There is no clear indicative time, and just taxing 30% steep rate tax and without giving a time of when this regulation would be given, this is just showing that the government is taking its hands away from being responsible to protect its citizens from certain harms that can come from these investments. And Your Lordships, the opposite councils also stated that for any law to be passed, it needs to have a proper purpose, clear objective. Here, the purpose is not stated, neither the clear objective is being given by the parliament to its citizens. When it is lacking, this is clearly lacking in the given scenario. And also, taxation policy is only has a strict interpretation. It cannot be given wider application. Only the words that are there have to be strictly interpreted. The council rests here.
All right.
Your learned opposite counsel. Okay, I'm so sorry initially on the first hand at the outset because you were a tad bit too fast for us to grasp the entirety of the question. But in order to satisfy your claims, with respect to the volatility in the first question, volatility can be assessed, ascertained, studied, and even predicted when it comes to stock market, like you put forth. But when it comes to transaction of such nature, like the digital ledger transactions and virtual digital assets, if you refer to the GARC committee report, it clearly talks about the lack of clarity and due diligence and other sorts of technical terms, such as lack of maturity and key management, governance, etc., etc. The quantum of volatility in this particular case is a lot more higher than the volatility which you're referring to when it comes to stock market. So those both cannot be compared when it comes to stock rates. So I think that would also be answering your next question pertaining to the doctrine of intelligible differentia, because thus this is not same. This cannot be compared. It cannot be put into the same pigeonhole when it comes to assessing the tax rate for the same. So the second question, you've talked about the strict interpretation. Strict interpretation will apply for machinery provisions and not for charging provisions. There are so many, for charging provisions also. But when it comes to the second question, third question, purpose. The co-counsel will answer it better.
So when coming to the third question where they talked about the purpose and the object, here the purpose of them imposing the tax is upon the income through the income which have been achieved through the transfer of VDA, where the object is being achieved because the tax is being applied upon the income itself. So that is what the council is trying to contend. Thank you.
Is that done, Courtmasters?
Yes, sir. Before we conclude the session, on behalf of Advocate Manav Jason Thomas, sir, I request the judges to please give feedback to our speakers to help improve their performance in the upcoming rounds.
All right. I think you all four of you have done a fantastic job. I am satisfied. I am
Very
satisfied.
good effort from both the teams.
Very good effort, and you've held your ground very well. I don't think I should say anything more. Mrudu?
No, so basically I observed that you people have put in a lot of your research in the right perspective from the right angle. It was very good. And your efforts to put across your arguments also were same. But in your rebuttal, especially from the petitioner side, like how your respondents had a problem with your speed. Maybe in the next rounds, you can go in a little slow so that, you know, your other side can get the question better. Probably the respondents were rushing with their pen to note down what you were saying. So that can be something for your future. You can just keep it in mind. But otherwise, good effort from both the teams. Very well done. Yeah. Courtmasters, over to you guys.
Thank you, ma'am.
Do you guys have any other questions or doubts regarding the issue?
Yes, sir. The ground on petitioners is actually quite a little bit weak considering the constitutionality.
Thank you so much. That is what even we've been wondering from morning. And actually, I didn't want to ask that question so that I don't disturb any of you.
Yes, sir.
Yes, sir.
But
we found it very
good insight. Good insight. Parliamento, do you also concur with this?
Even we felt the same.
We felt the same.
When talking, while we were researching about the petitioner side, that
But you guys should have the Income Tax Act in hand, and when you're challenging a provision, you should keep it ready. That's a very technical objection. Actually, in tax matters, technical objections are good. The petitioners took a stand that there's no section 247A, but any judge, I mean, they'll take it a little tough. I don't. I mean, why can't you read into 247A, petitioners?
So we thought that.
Did you take a clarification? You should have taken a clarification.
Yes, in the clarifications, they just said that
The bill has not been tabled yet, and there was some sort of confusion.
It is not tabled yet and added into IT Act. So we just thought that as it is not added, and also they didn't state about section 2 subsection 47, we thought it would be a scope to say that it is not.
No, isn't it on the same footing as 115 BBH?
It is like when section 115 BBH has come, immediately 198, I believe, and also section 2 subsection 47, 3 of them have come at the same time.
Yeah.
But they said that this bill has not come up yet, and also that is not being specified in the fact sheet. So we thought it would be a scope that there is no definition.
And the question was also that whether the section 115 BBH was, so there was a little.
No, but you can't read one. If 247A is not there, 115 BBH flies.
That was our argument.
That was our argument.
One more thing is, you guys should read chapter 12. I don't know how much it'll help either side, but chapter 12, you should see how all the other provisions are there also. That gives a terrific clue to 115 BBH, both on rate and as well as set off expenditure and everything. That can be a real submission which gives a clear answer to a lot of questions. I won't say more than that because you guys are still competing. Yeah. All right. Thank you so much. All the best.
Thank you.